Yesterday, the Missouri legislature passed Senate Bill 22, a law that changes how we get ballot summaries, targets ongoing abortion litigation in Missouri, and increases the Attorney General's power in court. It comes with an emergency clause, meaning it will go into effect immediately once signed by the governor. First, the ballot summaries. When you go to vote, you see a summary of the issue you're voting on. That summary is prepared by the Secretary of State and, at times, by the courts, if the Secretary's summary was challenged for being unfair. The new law gives the Secretary of State not one, not two, but 3 shots to write a summary before the courts do it for him. It also allows the summaries to be longer, so if you like flipping through pages at your local polling place, you will love that part. Second, the Attorney General's power is expanded by this bill. This bill includes a separate provision that allows the Attorney General to appeal any preliminary injunction that stops the state from enforcing any part of the state constitution, state laws, or state regulations. Oftentimes, when someone believes a law is unconstitutional, they ask the court to pause the effect of the challenged law. After a hearing, the court can order the law be paused. That's happening right now with Missouri's abortion laws. Last year, Missourians voted to put the right to reproductive freedom into the state constitution. A lawsuit challenged some of Missouri's extreme abortion laws under the new constitutional provision. If the Constitution conflicts with the law, the Constitution wins. The trial court found that some laws should be paused until the case is fully resolved because they are likely to be found unconstitutional. That was a loss for the Attorney General, and apparently the majority of the state legislature wanted to give him another chance. More chances for the government, kind of the theme of this one. So they are now giving the Attorney General the power to appeal that injunction and any other injunction on state power that he doesn't like in the future. Of course, the legislature chose not to give you or me that same power. What a surprise. Some folks have argued that this bill violates another provision of Missouri's Constitution, one that bans ex post facto laws or laws that are retrospective in their operation. Those are two different things in Missouri's Constitution. The ex post facto provision doesn't apply here. That applies to criminal laws or punishments. You can't be punished for a crime that didn't exist when you committed it. That's the basic idea. But this bill doesn't involve criminal activity. It's also likely not a retrospective law based on Missouri court rulings. Although it does allow the Attorney General to appeal one of his previous losses, this bill changes procedures, not necessarily the outcome. Injunctions have gotten a lot of press recently across the country, with national litigants seemingly looking for agreeable judges to pause federal laws. Providing a quicker appellate procedure could make some sense here in Missouri, but giving that power only to the state and not to the people is more big government pretending like it knows better. And especially with a government that apparently needs so many chances to get it right. They sure are doing a whole lot of pretending these days.